Good morning. Are you Nir Brown?
I'm not here today, special appearance.
I'm sorry, speak up so I can
Here
hear you.
today
You're appearing here today?
by special appearance.
Okay, what is your name?
I'm a third party intervener on behalf of artificial legal entity, not Nir Brown.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you have now identified yourself as Nir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
And at the child subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer? Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it again.
Overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige?
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk. Good morning, sir. Are you Andre Williams II?
Yes.
And this is cause number 24, DCCR 2286. I am going to take judicial notice of the court's file before we go forward. It looks like last year there was an evaluation for competency to stand trial. And Dr. Capon evaluated Mr. Williams and found that he was competent. Is there any other issues with regard to competency that we need to take care of today?
No, Your Honor. No, Your Honor.
All right, then will your client waive the formal reading of the indictment?
Yes, ma'am.
Sorry, it's my computer's something weird. All right, sir, in cause number 24, DCCR 2286, you're charged with the first-degree felony offense of murder, and that's from October 13th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes. State
tenders number 1.
No objection.
It's admitted. Is there any evidence other than what we've already gone over about any competency issues with Mr. Williams?
No, Your Honor.
All right, then, Mr. Williams, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again, you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 40 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification, right, that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. And Mr. Vasquez, if you and Mr. Williams will please have a seat at council table. We have a victim impact statement. We'll go off the record for that. Have a seat over there, sir. And how do you plead to that charge? Speak up, I'm sorry.
Guilty.
Are you pleading guilty freely and voluntarily?
Yep.
And are you pleading guilty because you did what they charged you with? The indictment also alleges you were previously convicted of driving while intoxicated April 1st of 2004, and then October 26th of 2007, and then after that, December 4th of 2015. And are all of those prior convictions true?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Judge Walker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison that would be probated for 5 years.
It's backwards. Should be 5.
Oh, 5 years probated for 10
Yes.
years. Okay, y'all are gonna have to explain that one on a DWI 4th. I don't,
Wait. 10 years 10 years probated over 5 years.
that's not what's written here. What's
Okay,
written
that's-
here is 5 years in prison probated for 10, and
That's transposed. It may be.
so 10 years. So if he violates,
Yeah,
it
10
would
years.
be the whole 10 years available.
Probation. Yes, ma'am.
5 years probation, 10 years in prison.
Correct.
Correct.
That's our agreement. Yes.
Okay, that makes it. Got it. Everybody okay if I make that modification?
Absolutely.
Thank you.
Sir.
Thank you, sir.
Well, Mr. Parker for that, Your Honor.
Yeah, I think it's probably Alan's fault.
And do you have that attachment for this?
Judge, he wrote it out on the back of that.
Oh, okay, perfect. Thank you. All right. And so now it looks like the agreement that you have reached with the district attorney is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And y'all wrote on count 1 only, but I think those prior counts are necessary for jurisdictional purposes, correct? I mean,
I think to play true to it, to be honest.
yeah.
Yeah.
Okay, because there is only technically one count.
Right.
Okay, just making sure. Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
Is that right? One of them looks like I don't want to, so we've got two priors that were
Judge, I think the
misdemeanors.
confusion is the way we list the prior DWIs is more of a
Paragraphs, but the
It's
last
helpful, yeah.
paragraph, it looks like is an actual
it is, Your Honor.
felony,
It is.
but it says relating to a driving while intoxicated second. Was it reduced? I don't want him to plead true to something that would actually enhance it up to a second.
Well,
Y'all know what I'm saying? That last one.
Judge, just for purposes of the record, we are pleading true to two priors.
Two priors.
For jurisdictional purposes only.
Okay.
And I'll tell you, the last one looks like a reduction, Your Honor.
All right.
it's a
So
misdemeanor.
what I'm going to do for the record is take those pleas of true on the first two enhancements. And then just waive the third one so that there's no issues.
Thank you.
Perfect. All right. And so state tenders number one,
No objection.
it's admitted. Is there any evidence that Mr. Ward is not competent?
None, Judge.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Sorry. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give you more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right over there. All right, we'll see you back at sentencing. Thank you.
Thank you, Your Honor.
Hi, Dre Williams.
Yeah, I kind of swearing with just something.
Yes.
Oh, are they working on that one? Okay. Okay,
The Courtroom is a theater of two souls. First, Nir Brown, who arrives not as a man, but as a legal entity, refusing his own identity. He faces hell, assault by impeding breath, strangling someone who loved him, and injury to a child. The judge, weary and sharp, gives him 30 days to find a lawyer. But Brown plays with language like a blade. I overstand. The judge's patience bends, but does not break. She warns, violate your no-contact order, and you go back to jail. Brown nods, smirking with syllables. You feel the storm coiled beneath his calm. Then the air changes. Andre Williams II steps forward. No games, no entities. He is charged with murder, first-degree felony. And when the judge asks how he pleads, he says one word: guilt. Not guilty, guilt. As if the word itself is a confession and a brand. He signs away his rights. He understands deportation, prison, the loss of a firearm forever. The judge finds him competent. Dr. Gapon already stamped that file. And then the sentence falls. 40 years in the Texas Department of Corrections. 40 years for a death on October 13th, 2024. Williams does not flinch. A victim impact statement waits off the record. Silent screams we will never hear. Two men. One hides behind pronouns and pseudo-law.